This is a lecture from Open Tuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
If you're listening to this lecture, it might be a good moment just to pause the recording and check which exam you've entered for. If you've entered for the international exam, you do not need to read this chapter. If you've entered for the UK exam, you must read this chapter. So it's for UK students only. It's right at the end of the note, so an obvious question is, will it come up in the exam? And the short answer is that if you're doing the UK exam, it may well come up, so you must not ignore it. The knowledge that's in this chapter is the same as the knowledge that you had when you either sat the ACCA England and Wales law exam, or you did a similar qualification, perhaps if you were doing a relevant degree or another professional qualification. So it's the same knowledge as before. I suspect some of it might have changed a little bit if you did the law a very, very long time ago. There are two major themes to make sure you understand. One is the difference between the two types of insolvency procedures, and the other one is to understand the meaning of fraudulent and wrongful trading. So there's just a reminder here in our notes about what insolvency actually means. And of course, at a basic level, it means that the value of the assets is less than the value of the liabilities. So if I was to sell the assets and could not repay the liabilities, that of course means that I am insolvent. And again, when you have been looking through the earlier chapters, you've seen the importance of the directors doing a going concern review and the auditors monitoring that going concern review when they're reaching their opinion on the financial statements. If unfortunately the company is in a dreadful mess, that means there are two alternatives under UK law, or two principal alternatives, and they are administration or liquidation. Administration in short terms means get someone who knows what they're doing to sort the business out, see if they can save it. So it's like the ambulance crew trying to save someone who's had an accident. Liquidation, unfortunately, means that the company is now finished. It's gone away, and forever it will never trade again, but we need to wind down the assets right at the end of its life. So administrators try to save the business. Liquidators are there to attempt, or rather to succeed, in closing the business down. Here we are on administration. This is where there's a decision that the company is perhaps savable. In that case, a qualified insolvency practitioner might be appointed to try and save the company. Once the process has been put into place, first of all, you will have their expertise, and secondly, what they will be able to do is to effectively freeze the company's debts for a period of time. You know how if you're in a financial mess, everyone is breathing down your neck. You can't concentrate. You can't see which way you're going. What the administrator is able to do is to turn to everyone and say, wait, I will see if there's a better way out of this where we could all benefit, and then perhaps they're able to save the company. Well, occasionally the court is involved in an administration, so that sometimes happens, particularly if the company decides, and against the company effectively, the members tell the company, or the directors, or the unsecured creditors, again, petition the court. They can ask for an administration order. Obviously, it's more expensive if you go through the court, but if they do that, essentially, the judge will have to decide, is the company on the way down? Is it likely to be insolvent? And could it be saved? Because if it can't be saved, they should go to liquidation. Sometimes you don't need to use the court, and in particular, that will be someone who has lent money to the company and it's secured by a floating charge. Now, a floating charge, you met that first in law, is a charge over the assets generally. So it would, for example, again be where the loan has security, the security for the loan is, it's not just the land and building of a company, but it's all of the assets of the company. So the security for the loan is maybe, and this is not really legal jargon, but I'm just saying all of the assets of the company. I'm going to call it BOXO. BOXO Limited, using UK jargon for company. So the security for the loan is that. In that case, if you have a floating charge, the charge will crystallize when the company defaults or breaks one of its covenants. And in that case, you don't need to go to court. So essentially, you can contact an insolvency practitioner directly. They will then have a look at the business, either way, whether it's the court or not. They will set out a plan to try and decide if they can sort the company out. That plan really has two matters. Number one, they decide how to change the business, which often means changing the management. And secondly, they have to decide on a compromise with the creditors. Would you accept your money 3 years later? Money in 3 years is better than no money today. The creditors ultimately, again, will vote on those decisions. So the administrator has fairly draconian powers. As it says, the administration will probably be for a year. By then, the company has been saved, or it's in ruins. If it's in ruins, they'll hand across to a liquidator. That's administration. What's the point of administration? The point of administration is to save the company, if possible. If, on the other hand, the company is unsavable, you've got the process of liquidation, and there are two types of liquidation, otherwise known as winding up. The two types are compulsory, which is here, and then just a bit further in the notes, you've also got voluntary liquidations. Compulsory liquidations are very much a last resort. Usually, the creditors will go to the company and say, look, you have to sort this out. They will speak to the directors. The directors will speak to the shareholders. The shareholders will say, okay, it's over, and they'll go into voluntary liquidation. If the directors are a bit silly, and the members are a bit silly and won't agree to this, there's no alternative but to use a judge in court. What's interesting, and you might remember this from law, it is very easy to put a company or certainly make an application. All you have to establish is that you have to file a letter, and you'd use a lawyer in practice to do it. You'd make a statutory demand for money that's overdue. If the debt's more than 750, the company doesn't meet that demand within 21 days, it's evidence that they can't pay their debts. So, again, creditors might frequently use this as a vehicle to get money out of a company that's being a bit slow in paying. In which case, again, often the company is in such a mess that insolvency practitioners don't really want to touch it. So the person that would run the insolvency initially, again, is known as the official receiver. So the official receiver effectively works for the government, or strictly the court. They will take charge of the liquidation initially. And then, of course, They will decide what the assets are. They will try and bring in the assets together and then settle the liabilities. So official receivers are used with compulsory liquidation. Strange they use the word receiver, isn't it? But it's the language that they use. It's a government official. Usually it's inability to pay debts. In some circumstances, compulsory liquidations are used for other reasons as well. More normally, the company will decide on its own bat to actually go into liquidation. So when you talk about voluntary liquidations, these again are without the court. Members voluntary, I'm not sure are very important in our syllabus, but these are where the company is solvent. So if the company's been set up for a specific purpose, perhaps to do something during the Olympic Games if they're being held in a certain country, the project has reached its end and they just want to bring the company to a close, they could use a members voluntary liquidation. I think the one that's much more relevant to us though is the creditors one. This is where the company is insolvent, in which case, in very simple terms, the creditors will put pressure on the company, the directors will put pressure on the members, and the members will say, well, let's pass a resolution and say it's all over today. Special resolution, you might remember, is 75% of the shareholders who vote, who turn up to vote or vote, send someone on their behalf. In that case, no court is involved. So when you're thinking about administration and liquidation, perhaps an easy way to learn this is for both of them, you can avoid the court, and for both of them, in some circumstances, you must go to court. Administration, again, you avoid the court if you've got a floating charge. Liquidation, you avoid the court if the directors are sensible, the shareholders are sensible and agree to the liquidation process. As always, if you want more detail or you need to recap more detail, please look back at our law lecture notes. After that, of course, the debts are then satisfied. So who gets paid very first? Well, obviously, the liquidator will get paid first effectively. So they're going to come out of this very clearly up front. Depends again, but generally, people who have fixed charges on land and buildings would often get paid second. There's then a group of preferential creditors. So things like back wages get paid next, or some back wages. After that, you're then going down, if there's any money left, then the floating charge holders, then the poor old unsecured creditors, and that's you and me, isn't it? And of course, there'll be nothing left now, but if there's anything left at the end, which there won't be, the shareholders right at the end. Again, there's more detail on that in our law notes. Above all, obviously for directors, it's better to have an administration because nobody likes to see a company disappear. Administration itself is good because the shareholders might get something in the long term. The creditors, again, might get something probably again in the long term. And of course, anything to keep the staff in work has to be a good thing. The other thing within insolvency that you must pay attention to is this topic of fraudulent and wrongful trading. So, if you went back a long time in company law, the only one that actually really existed was fraudulent trading. And because it was so difficult to get actions under fraudulent trading, they introduced another concept known as wrongful trading. You know, when you do a sum at school and you get the answer wrong, you go, well, I got the answer wrong. I learned from the mistake. That's a bit like wrongful trading. It's doing things in the wrong way. It's not setting out to deceive. It's much easier to understand that someone's done something wrong than to suggest they've deliberately tried to deceive. So, fraudulent trading is very, very rare in terms of actions going through, but it's where anyone who's involved in the fraud, so principally that would be directors, but it might be others, is setting out to deprive the creditors of money in some way, and it's a criminal burden of proof. It's where you can be satisfied beyond reasonable doubt, again, so you're 90% sure, and you have to convince a jury in court. In those circumstances, if directors have committed fraud, they could go to jail and they may face personal liability for the company's debts. They might be disqualified. I'd have thought that was the least of their problems if that happened. It's very rare in practice to see this. And most of our directors in most of our questions are not going to be deliberately deceiving creditors. I don't think so. So it's probably not a massive issue in the exam, unless of course they ask what it actually means. But you deliberately set out to deceive the creditors. You deliberately take on new debt when you know that you haven't got a chance of paying it. Yes, you could end up in jail. You could end up having to contribute to the company's debts. You might be banned from acting as director, but it's not so much of an issue. The one that causes directors to lose sleep is the one on the other side that's common: wrongful trading. This is something that only applies to directors. So it's only directors. Shadow directors, you may remember that term, is where there are people not formally appointed as directors, but who seem to be running the company anyway. Anyway, what the court does here is look at the perspective of a reasonable person and say, look, you've wrecked this company. Would a reasonable person have done that? So it's not because they're falsifying stuff, it's because they just don't understand. They take their eyes off the big picture. They're great people of integrity, but they have no understanding of how to make money. So if they act when it should have been concluded that a reasonable person would have stopped trading, then they may be liable for wrongful trading. When it ought to have been concluded, there was no reasonable prospect of avoiding liquidation. I remember as an auditor, an audit client, saying to that audit client, why did you enter this contract? He said, I wanted to keep the staff in work over Christmas so they could buy their family presents, which is terribly sad, but that was wrongful trading. The burden of proof, 51%, not 90%. If it's likely a reasonable person, again, would not have acted in that way. It's not a crime. However, it's civilly wrong, so you may be asked to contribute to the debts. The general concept of separate legal personality, of course, is that if the company goes down, the directors are not liable for its debts. But in this case, that the court will say, well, we think you should contribute $100,000 towards company assets, which can then be used to help compensate the creditors. And again, you may face disqualification. So it's not a big topic, is it, insolvency? The two principal things to make sure you've had a look at are: what are the two different procedures, administration and liquidation? What are their objectives, which is better? Secondly, what are the two types of problem that directors face when a company is insolvent: fraudulent versus wrongful trading. That's it for insolvency.